A lot of my clients have been asking me what actually happens if I receive a notice to appear in immigration court. So that's what this video is about. I'm gonna go through two separate scenarios where someone entered the US legally and has some immigration options available, such as adjustment of status. And I'm gonna go through another scenario where someone entered without inspection and what defenses might be available to them and what the immigration court process actually looks like. I find that when I explain things like this to my clients, it reduces their fear a little bit. It takes it from being an abstract, unknowable, scary thing to something that they could wrap their heads around. So I hope it has that effect for you as well. Removal proceedings, also known as deportation proceedings, they generally take place in a non-detained setting. So the vast majority, like 90-something%, I don't know the exact numbers, but an overwhelming majority of the people who are placed into removal proceedings receive a notice to appear by mail or it's hand delivered to them. This could be if you enter the US as a green card holder in an airport, or if you encounter ICE along a border or within the United States, they'll process you and oftentimes they'll give you a notice to appear in immigration court. There are some rare scenarios where you will be physically detained. You know, these are all over the news right now, but those are high profile cases. That's not what the average person encounters unless they have some sort of criminal history or they're otherwise likely to be a danger to the community. But that describes a very small percentage of immigrants, especially people who've been here for a long time. So what does it actually say on the notice to appear? The notice to appear basically alleges why you are removable from the United States. It'll say something like, you are not a citizen of the United States, you are a citizen of this country, you entered the US on this date, and you are currently not present with authorization. Something like that. You know, every notice to appear says different things. It depends on why you are removable from the United States. And then at the bottom of the document, it'll usually say you are to present at immigration court at this day, at this time. Sometimes it says TBD, to be determined. Regardless of whether it says TBD or provides us an exact date or time, oftentimes it's incorrect and the date and time changes because the ICE ERO office, the Enforcement and Removal Operations Office, has to file this NTA with the immigration court, and then the immigration court determines a date and time that works for them. If you have a notice to appear, the first thing you should do is go to Google and type EOIR case status, and it brings you to a case status website where you can input your A number, which is found at the top right or sometimes top left of the notice to appear. It's next to your name. It begins with the letter A and then it's a 9-digit number. You can input this on the website and it'll show you the exact date and time. If you input your A number and it says like no case found, that means that the notice to appear has not yet been filed with the immigration court, and as of that moment, you are not yet in removal proceedings, even though you received that notice to appear. Usually, the first hearing, the first court date, is like 6 to 12 months out into the future. But this is case by case. It depends on the location in the United States and what their backlogs are like. And this is just the first appearance. The first appearance is referred to as a master calendar hearing. And this is going to be a hearing where like 50 immigrants show up at the same hearing. They're all scheduled for like 8:30 a.m. or 9 a.m. depending on the judge and what their time preferences are, or like 1 p.m. And everyone shows up at this time and you just wait for hours until it's your turn. The master calendar hearing, once it is your turn, is usually just like 5 minutes. If you have a lawyer, the judge will just talk to the lawyer usually. They'll go through the allegations. You'll either admit them or deny them. If you deny them, then the burden shifts to the Department of Homeland Security to prove the allegations. And then usually, if they are able to prove them, or you just admit them, which actually happens most of the time, the judge will determine that the immigrant is in fact removable. They'll ask you which country you would designate in the event that removal becomes necessary. And then you can either say what country they're from, and that's where they'll be removed to, or you could respectfully decline to designate a country. And then the Department of Homeland Security will just say whatever country they think you're from, and the judge will designate that to be the country. After removal removability is established, which takes like literally 60 to 90 seconds into the hearing. You have to indicate what defenses from removal you will be seeking. And I'll go through a couple options here, but there are a variety of options depending on what your immigration status is, what family members you might have in the United States that have immigration status, how you entered the United States, and a couple other variables. But the three things I'm going to talk about just briefly, one of them is voluntary departure, one of them is adjustment of status if you're eligible, and one of them is cancellation of removal. So voluntary departure basically means exactly what it sounds like. Like you are just gonna voluntarily depart the United States. The main benefit of this, if the judge grants it, they don't have to, but they usually do in most situations. It makes everyone's life easier. You're just saying, you know what, I'm gonna leave. Voluntary departure, the main benefit is you do not receive a removal order if you actually depart the United States. Usually there's like a 90 to 120 day window during which you must depart. The judge will grant it, they'll set a departure date, and then you have to leave during that window. After you leave, you're supposed to go to a consulate or embassy abroad to verify your departure and just have that in your records. And this will help you down the road if you intend to re-enter the US legally, like you have a family member who could petition for you down the road, and you don't want to have a removal order on your record, which would make it way harder for you to ever legally re-enter the US. Voluntary departure might be an option for you, but most people in my experience don't want to voluntarily depart. So the next option that I'm going to talk about is adjustment of status if you're eligible. I do a ton of marriage-based immigration cases, and people ask me like, what's the worst thing that could happen if we show up at the interview and they just detain us? First of all, that's probably not gonna happen. Like that happened once in Florida recently to like 3 different people, I think one of which had entered legally with a visa. I don't know exactly what the scenario was there or why they were targeted, why USCIS cooperated with ICE in that specific scenario. But I haven't seen it happen to any of my clients, and I haven't heard it happening to any of my other colleagues' clients throughout the United States. So the probability of that is incredibly low. And when people ask me how I could be so sure, what I explain is that it doesn't really make sense for ICE to place you into removal proceedings if you qualify for adjustment of status. And then I take them through this scenario. Let's say that they do place you into removal proceedings. What would we do? So this is what we would do. When we get to the stage of the first master calendar hearing where the judge asks, what defenses are you seeking from removal? I would say, Your Honor, we're seeking adjustment of status. My spouse entered the US with inspection and has a US citizen spouse or a US citizen child who's over 21, and they're immediately eligible for adjustment of status. And then the judge might ask, have you filed an I-130 yet? And then I'll say like, yes, we just filed one. Here's a copy of the receipt notice. And then usually at that stage, the judge will either terminate the removal proceedings and say like, okay, no need to come back to court. USCIS can have jurisdiction of this. You don't need to continue with the adjustment of status here in court. But the judge does have the option to keep the case open and have you just file the adjustment of status application directly with the immigration court. If you are in removal proceedings, you generally speaking have to file everything with the court or get it terminated or dismissed so that USCIS has jurisdiction. There are some exceptions. The most notable one is if you are an arriving alien, which means the notice to appear says you are an arriving alien. This is usually what happens when you are NTA'd at a port of entry or airport in some scenarios. If the judge wants to keep the case open until the I-130 is approved, as soon as the I-130 gets approved, normally at that point, the Department of Homeland Security will agree to terminate the removal proceedings or dismiss the charges of removability. Or you could just make a motion for the judge to terminate, and usually that's what will happen. The judge will just grant the motion to terminate because your client is now eligible for adjustment of status. So if you're applying for adjustment of status through marriage and they place you into removal proceedings, it's usually not the end of the world. We can usually defend you unless there's something else going on and it's not a clean case or there's some other aggravating factors. Policies can change, but right now, Most judges will terminate removal proceedings once you have an approved I-130 and you show that you're otherwise eligible for adjustment of status. But even if the judge didn't terminate removal proceedings, once the I-130 is approved, we would just file the I-485 application directly with the immigration judge, and then we would hold a little mini trial to see if you're eligible for adjustment of status. This would be more complicated than just going to a USCIS interview, but if you have no criminal history, no major issues, I don't see any reason why your I-485 application would be denied in ordinary circumstances. Now, what happens if you entered the US without inspection? Your remedies are much more limited in this scenario, but I'm gonna talk about one notable one that a lot of people pursue called cancellation of removal. Cancellation of removal, there's two versions of this. One of this is for permanent residents and one is for non-permanent residents. The one for permanent residents is not the one I'm talking about. That's most likely to be like the permanent resident was convicted of some crime and they want to apply for cancellation of removal. The requirements for that are totally different than what I'm mentioning here for people who entered without inspection. Cancellation of removal for certain non-permanent residents, also known as application 42B, has a couple requirements to qualify. If you win your case, you can actually go from being completely undocumented in removal proceedings to a permanent resident if you're granted relief. But if you're denied, you receive a removal order. There used to be a middle ground under Biden and actually every other president where if you qualify and you're generally a good person, you've been here for a while, you have significant ties to the US, you're like paying taxes, you might be able to just get your case dismissed and you don't have to risk a removal order, but you also, once it gets dismissed, you're not a permanent resident, you're just kind of in a gray area, legal limbo, you're still undocumented, but you're not being actively removed from the United States. To qualify for cancellation of removal, there are three main requirements. One, you must have been physically present in the US for at least 10 years before issuance of the notice to appear in immigration court. Two, during these 10 years, you must have been a person of good character, and generally speaking, you shouldn't have any disqualifying crimes. And three, you must have a child, spouse, or parent who is a permanent resident or US citizen, and this qualifying family member must suffer extreme and unusual hardship if you are removed from the United States. Extreme and unusual hardship is a very high evidentiary burden. Normal hardship that like a child would experience or a spouse or parent would experience do not qualify. You need to rise much higher than the normal requirements for hardship. For example, if you have 2 US citizen kids and you're undocumented and you're applying for cancellation of removal to try to win your case and get a green card, and your kids are pretty normal kids, they have no major health issues, they have no major emotional issues, they're doing well in school, it's gonna be extraordinarily difficult to prove that they are gonna suffer more than a normal kid who's losing his parent to deportation. And it would need to be a lot more than just normal consequences of hardship, although that's a subject of debate, and it depends on which immigration judge you get and how favorable they are towards these cases. Anyway, so at this point during the master calendar hearing, you would tell the judge what relief from removal you're seeking. And in some cases, the lawyer might say like, hey judge, I just got hired like 2 days ago. I need some time to investigate. Can we schedule another master calendar hearing to give me some time for attorney prep? And the judge might say like, okay, next hearing is gonna be in like 3 to 6 months. This is the hearing date. I'll see you then. If you do tell the judge what defenses from removal you're seeking at the master calendar hearing, the judge will then schedule an individual merits hearing. And this is gonna be like a 1 to 4 hour hearing. It could take longer than that. It could be a multi-day event in rare instances, usually not. And during this hearing, you're gonna basically do a full trial. You know, some people call it a trial. I like to call it more of a mini trial in front of an administrative judge. Technically, it's just an administrative hearing, but it does have the style of like a mini trial. Like first, you would start by going through the evidence and what evidence should be admitted to be considered by the judge. Then you would do direct examination, where your attorney asks you specific questions so that you could explain how you qualify for this defense from removal. And then the government will do cross-examination, and then you'll do redirect. Cross-examination is basically where they try to poke holes, they can ask you leading questions, and then redirect is where you try to rehabilitate any problems that were caused during cross-examination. After this, the judge might go through some more issues with the lawyers, issues for consideration. The attorney might also do a closing statement at the end. Usually at the end of the hearing, the judge will take some time and then issue either a verbal decision or a written decision right then and there. Some judges will say like, all right, we're done for today. We're gonna schedule another hearing for a decision, and they'll schedule the hearing right there where you just come back and they read the decision out loud to you. If you are ordered removed, either at this hearing or during the decision that's subsequently scheduled, you are not gonna get arrested right then and there, unless there's something extraordinary or extenuating. This is a question a lot of people have, like, am I gonna leave the courtroom when I go to my immigration court hearing? And up until now, like the middle of May or the end of May 2025, the answer is yes, you're gonna leave the courtroom. And the main reason for that is because the removal order is not final when the judge orders you removed. It becomes final 30 days later. And you have this 30-day period to file an appeal with the Board of Immigration Appeals. And if you timely file an appeal during this 30-day window, the removal order will not be final until a final decision is made by the Board of Immigration Appeals, which could easily take like 6 to 24 months. And by the way, if you had a work permit because you had a case pending, for example, asylum pending or adjustment of status pending, or even cancellation of removal pending, you could have in some instances qualified for a work permit. You could actually continue to renew this while the appeal is pending. What I typically tell people is that once the order becomes final, either 30 days have passed and you don't file an appeal, or the appeal gets denied down the road. It could be faster than 6 months, but historically it hasn't been. That could change in the future. Once the appeal is denied, at that point, the real risks begin, and you are totally fair game for ICE to begin targeting you for enforcement of that removal order. The easiest people for ICE to go after is people who have final removal orders, because they've already exhausted all of their judicial remedies. They don't really have the right to go back into immigration court in most instances. You might be able to get your lawyer to file a motion to reopen the old removal proceedings, and that might persuade ICE to back off for now. But generally speaking, the people that they love to target are people who have final orders of removal, and that's for obvious reasons. All right, guys, so that's generally what happens when you are in removal proceedings. If you are detained, it's pretty much the same thing with some caveats. You might have a right for a bond redetermination hearing where the judge will hear arguments to see if you should be released and sent to the non-detained court docket for the remainder of your removal proceedings, which is generally preferable because it takes longer, you have more access to an attorney, and you're free. You're not in a jail. When you are detained, the cases are generally accelerated, expedited. So the whole thing that might take ordinarily 2 years for a non-detained person could take like 2 to 3 months, or even faster for someone who is detained. If you have any questions or you want to go through your specific immigration issue, schedule a consultation directly with me. You can find my information in the video description below. I generally make videos about family-based immigration, naturalization, immigration court, and just changes to immigration policy under the Trump administration. So if you're interested in these topics and you want to hear it directly from an immigration lawyer's experience, be sure to subscribe, and I'll see you guys next time for another video.